Now it is my moment of pride to introduce today's keynote speaker, Honorable Mr. Justice Akil Kureshi, sir. Ladies and gentlemen, we respectfully invite Honorable Justice Kureshi to educate us on the subject.
Chief Justice Shrivastava, who was my pillar of strength when I was in Rajasthan High Court for a brief while, all the dignitaries on and off the dais, friends, ladies and gentlemen, very good evening to all of you. I'm honored to be here present before you, and there are many reasons why I'm here today. Paying homage to a great personality like late Justice S.C. Agrawal and contributing in a small way one can to all his activities related to him is one of them. The other reason is that a few weeks back I got a phone call from Justice Dave requesting me to come here. The date of my choice, the topic of my choice. Justice Dave's word is my command. Sir, at my age, if I can have half the zest for life, the sharpness of mind and recall of finest details of events decades past, I would consider myself fortunate. The other reason is that I have gone on record stating that the 6 months or so that I spent here as the Chief Justice of Rajasthan High Court was the most enjoyable period of my 18 years as a judgeship. I was not going to miss this for anything. The last reason is, my friends, when I was a judge, I was told that there are 3 stages in a judge's career. The first stage comes when, first 5 years, when he constantly thinks he's always wrong. The next 5 years is the second stage where he thinks he's always right. And the last 5 years he does not care whether he's right or wrong. But after retirement I realized that the fourth stage, where others don't care whether you are right or wrong. So when I'm given an opportunity to speak, I'm not going to give it up. Friends, the society today in the country is at a cusp of revolutionary changes. It is a time when the society is truly trying to search for its identity. And this is manifested in many ways. Across the country, the courts are trying to answer one question in different forms. Where does the limit of law end and the personal limits begin? Take the case of Sabrimala. A woman goes to Supreme Court and says that a practice in a temple which prohibits a woman's entry between a certain age is unconstitutional and declares so. Take the case of Nas Foundation. People with different love preference wanted to establish the right and asked for decriminalizing consensuous gay sex. The Supreme Court essentially came to the conclusion that what 2 consenting adults do in the privacy of their bedroom is not the concern of the state or the law. Take the case of triple talaq, where age-old practice of a Muslim woman being divorced by repeating one single word thrice has been declared as unconstitutional. A lesser known case is of one Gulrukh Gupta. It's pending before the Supreme Court. Gulrukh is a Parsi woman married to a Hindu boy under the Special Marriage Act, neither of them having abandoned the religion. Gulrukh Gupta has gone to the court and said, my parents are aged. When they pass away, the Parsi Panchayat will not permit me to perform their last rites because they are performed in the inner chamber of the Parsi Agyari where there is Atish Behram, the sanctuary to enter the center sector. declared that this practice is unconstitutional. These are fascinating times, a fascinating debate on the constitutional principles touching the society are being debated across the country in different courts, in different forms. And therefore, when we try to understand these nuances, let us go back to the drawing board and see how the Constitution has evolved so far. And therefore, the topic that I have chosen for presenting primarily for the law students is 3 judgments which change the way we look at our Constitution. No marks for guessing. First judgment, of course, is Keshavananda. Not only because it's one of the longest judgments and by the strength of 13 judges which has not been repeated since or before, also because of its implications. But before we go into the implications of Keshavananda, let's go back to the history. Friends, let's try to remember our history of constitution making. As Mr. Shrivastava pointed out, the Constituent Assembly was formed even before the independence. 9th December 1946 was the first meeting of the Constituent Assembly which took place. Pandit Jawaharlal Nehru addressed the Constituent Assembly on the aims and objects the Assembly wants to achieve. And he said that the entire world's focus and eyes are on us, what we are going to go next. The times when the Constitution was being framed by this Assembly were very uncertain. Partition of the country was getting increasingly clear. There was violence across the border because of the partition possibilities. The world had just recovered from the devastating World War, which left the victor as well as the vanquished bleeding. The framers of the Constitution, some eminent personalities, Pandit Jawaharlal Nehru, Dr. Ambedkar, Dr. Radhakrishnan, Rajendra Prasad, Sardar Vallabhbhai Patel, they were all freedom fighters who had spent years in jail, they had suffered at the hands of the colonial ruler of grossest possible human rights violations. They had also witnessed from close quarters what the Nazi regime had done to fellow human beings during the Second World War. And therefore, dedicating a whole chapter to protection of fundamental rights was therefore imminent. 13 volumes have been documented on debates of the Constitutional Assembly, and all this has been discussed beautifully in 2 classics written by Austin Granville. As students of Constitution, I request you to go through both the books very carefully. First is on Making of the Constitution, Cornerstone of a Nation. He talks about how the Constitution was framed, what were the debates, what are the issues came up, who said what, and in chapter-wise, he threadbare discusses the nuances of framing of the Constitution. And the second book, which he wrote sometimes in the mid-90s, is Working of a Democratic Constitution. How it worked out over a few decades of its existence. Friends, once the Constitution was prepared, it was adopted on 26th of November 1949. Therefore, we celebrate 26th November as a Constitution Day. It was formally adopted on 26th of January 1950 and presented to the nation with a solemn resolve to achieve social, political and economic justice for all. And thus began a journey of a nation from the days of poverty, illiteracy, hunger and malnutrition to better future and equal opportunities to all. This was not a simple document of the governance. This was a vision document of an entire nation. Thus began a social restructuring and re-engineering of social classes, a peaceful social revolution never imagined in the history of mankind. Just think of the diversity of the nation, the cultural, linguistic, geographical, historical diversity, from north to south and east to west, combined together trying to form one nation and trying to march forward to bring about true equality in the society. That was a vision, that was the dream of the framers of the Constitution. Once the Constitution was framed, 2 of the leading personalities, Dr. Ambedkar and Dr. Rajendra Prasad. Both expressed similar sentiments in slightly different language. They said that we have tried to frame a good constitution and we hope it has turned out to be a good document. But whether this turns out to be a good constitution or not will depend on how it is worked out. The people who work this constitution out, if they are people of stature and courage, this will be a good constitution even if it has some defects. The first real test of the constitution did not take place in the court of law, but between two of the highest dignitaries, the first Prime Minister, Pandit Jawaharlal Nehru, and the first President, Dr. Rajendra Prasad, ironically, who had played leading role in framing the constitution, had huge difference of opinion on the true role of the President of India under the constitution. Dr. Rajendra Prasad refused to accept that the position is that of a rubber stamp of a president. He wanted much larger role. He wanted the ministers to brief him regularly on some changes, on policy decisions, on framing of laws. Pandit Jawaharlal Nehru would have none of that. He said we have adopted the Westminster's model where the president has to act under the aid and advice of the Council of Ministers and is bound by such aid and advice. The statement was broken when the Attorney General Motilal Sethalwal gave a written opinion and sided with the opinion of the Prime Minister. As soon as the constitution was framed, there was a huge demand for agrarian law reforms. Till independence, land holdings in the villages, agricultural land holdings, were in the hands of few landlords. Thakurs, Barkhalidars, Zamindars, whatever name called, they were holding 1,000 acres or sometimes more. These land holdings were subdivided into small tenancies. The tenant would surrender one-third or sometimes one-half of the crop share to a landlord who has not even visited the land once in the entire year. Sometimes a failed monsoon was a good news for the landlord because the tenant would be forced to borrow money to repay the debts which he has borrowed and the crop has failed and he cannot repay. And the landlord, a small tenant, would overnight be turned into a bonded labor. Across the country, therefore, there was a huge demand for law reforms. Every state, from Bihar to Bangalore to UP to Gujarat to Maharashtra, Karnataka, brought land reform laws in one single line, abolishing tenancy, abolishing zamindari as a class. The state entered the shoes of the zamindars and maintained the eminent domain of the state. The land tiller became the deemed owner of the land. This was not going to be accepted lightly by the landholder topics, and these laws were challenged. The fundamental question was, can the state acquire compulsory private property without paying just compensation? The government did not have enough funds to acquire all these lands and give it to the farmers. Some of the high courts struck down similar laws. The government took the amendment route to cure this, to overcome this obstacle. And therefore, even before the country went for its first general election, one of the longest constitutions in the democratic world underwent its first amendment. And these amendments were challenged. And range of topics came up for consideration in Shankari Prasad Singh Dev judgment. 5-judge bench considered this. The arguments were, does a constituent assembly have power to amend the constitution because it's not regularly elected parliament? Does the parliament have power to amend fundamental rights? Is Article 368 source of power or just a procedure for power? What does amendment mean? Does it permit the parliament to just make small corrections and changes, or can it fundamentally change the very character of the constitution? All these questions were answered in the first judgment of 5 judges bench in Shankari Prasad Singh Dev, holding that the parliament has fullest power to amend any part of the constitution, including the fundamental rights chapter. The topic did not end there. It went again before the 5-judge bench in Sajan Singh. Sajan Singh again took the same view, but 2 eminent judges sowed the seeds for doubt. Justice Hidayatullah said that the fundamental rights chapter guarantees so many important rights to a citizen, I doubt whether it is a mere plaything of a majority. Justice Madholkar for the first time flirted with the idea of something like basic structure. He said, can there be something of a basic feature or structure which cannot be tampered with? But neither of the two learned judges felt strong enough to dissent, and therefore we had another constitution bench judgment unanimously holding that any part of the fundamental rights can be amended by the parliament. I see Golaknath, as you know, majority of 6 versus 5 held that Parliament cannot amend any of the fundamental rights. Since it had a big impact, it was made applicable prospectively. This prospective overruling was propounded for the first time in Indian constitutional jurisprudence. The government was in a hurry, did not have patience for all these deliberations. Matter went to a larger bench of 13 judges, and Keshwan and the Bharati Supreme Court held, yes, Parliament has the power to amend, but not to destroy basic feature or basic structure. This judgment is extremely important from 2 elements. One, that it set the tone of balance between executive, legislature, and the judiciary. It made judiciary and the constitutional courts the final arbiters of legal interpretation and the limits of powers of the parliament. And second and most impactful outcome of this judgment was that it made the Constitution of India immune to majoritarianism. The very ethos of the Constitution is that majority cannot write the roughshod over minority. And therefore, it recognizes the principle that momentarily even majority can make errors. Every democracy, every republic has a right to trial and error, but not by destroying the basic structure of the Constitution. But the framers of the Constitution, after due deliberations, have found something fundamental that cannot be destroyed by the entire majority. And this has been used time and again in later parts, most effectively in NJSC's striking down judgment. The second judgment which comes to my mind is of N.M. Thomas case. Most underrated, rarely referred to, but in my opinion, an extremely important element it brings to the way we look at our Constitution. Till this judgment, my friends, you are aware of Article 14 is an equality clause, guaranteeing equality to every citizen before law. There will be equal protection and equality before law. 16.1 is a facet of equality in public employment. So Article 16.1 says, every citizen shall have equal opportunity of in public employment and there will be no discrimination. Article 16.4 says nothing said in sub-article 1 will prevent the state from making any laws for reservation in favor of scheduled castes and scheduled tribes, which in the opinion of the state are not sufficiently represented in public employment. Till this judgment in the year 1976, the Supreme Court had twice in Balaji's judgment and Devasthan judgment taken a conventional view. That Article 16.1 is a rule, Article 16.4 is an exception to the rule. Justice Subbarao in Devasthan judgment had tried to suggest otherwise, but he could not carry majority wisdom. In N.M. Thomas, the majority, concurring judgment of a brilliant exposition by Justice Matthews, he said that Article 16.1 itself is sufficient to permit reservation, because equality can be only amongst equals. Treating unequals as equals itself is inequality. He propounded the concept of proportionate equality. He also used the principles of directive principles to govern the rule making as well as the decision making processes. And he therefore said, Article 16.1 itself permits reasonable classification, permitting reservation in favor of backward classes. 16.4 is more emphatic way of saying what Article 16.1 says. Brilliant exposition. It turned our Constitution on its head the way we understand it. And the last judgment I will present for your thoughts. Somebody may be uncomfortable with this judgment in this list. Somebody may think it's controversial, but it's my firm choice is ADM Jabalpur judgment. ADM Jabalpur you are aware, is a judgment on the fundamental rights protection of Article 21 and 22. Let's go back to a little bit of history behind this. In the year 1975 and 76, India was going through very uncertain times. The students' movement in Gujarat, Navnirma, followed by the students' movement in Bihar, led by J.P. Narayan. The opposition had come together, there were strikes, there were gheravs, there were demonstrations. This culminated into a judgment from the Allahabad High Court Justice Sinha striking down the election of the then Prime Minister Mrs. Indira Gandhi. In appeal to the Supreme Court, only a limited stay was granted. Few days later, internal emergency was declared. The presidential order prohibited enforcement of Article 14, 20 and 21 and 22. Students' union leaders, labor union leaders, political opponents, everybody was put behind bar under preventive detention laws, principally maintenance of internal security, MISA. Many of these detentions were challenged in high courts across the country. One of the preliminary objections taken by Union of India was that these petitions are not maintainable because these rights are not enforceable. 9 high courts across the country rejected this challenge. The matter went to Supreme Court. 5-judge bench was constituted. In a majority of 4 versus 1, the Supreme Court held that fundamental rights to life and liberty are suspended and a citizen has no right to challenge their detention, even if it is hopelessly illegal or without jurisdiction. The shining, lone, dissenting, courageous view came from Justice H.R. Khanna. In his brilliant exposition, he said, I do not think that right to life and liberty is only protected by Article 21. Article 21 is not the sole repository of a citizen's right to life and liberty. It inheres in every member of a civilized society. Abolish your constitution, abolish Article 21, a citizen's right of life and liberty are still intact. And the aim in the last paragraph, whether you have time and interest to read the entire judgment or not, do read the last paragraph. He said that when I was penning my dissent, I knew that I'm in minority. And I still was convinced I should express my opinion. And the reason he gave, quoted a Supreme Court judgment of USA, United States of America, and said, a dissent in a case like this is to appeal to the brooding spirit of the generations to come and to correct the errors which the history will recognize later. What he did not write in this judgment, and which became known to the public later on, was that he was forewarned that if you go ahead with this opinion, you will not be made the Chief Justice of India, which by his right, by seniority, it was his due. He went ahead with his opinion, true to the promise. He was denied judgeship, Supreme Court Chief Justiceship. He promptly resigned. New York Times wrote an article and said that if the Indian democracy has to limp back to its original glory of past 25 years, somebody should pay a tribute to this man. My friends, ADM Jabalpur was the lowest point in the history of the Supreme Court of India. To borrow the phrase from stock market, it had bottomed out. It could not go lower than that. Otherwise, our august body, always seen to be siding with protecting the citizens' rights, failed at the most important moment. Justice Chalveshwar, decades later, in his dissenting NJAC judgment, said that this teaches us one important lesson, that under pressure, if executive can buckle, so can judiciary. These 3 judgments I have chosen out of many landmark judgments the Supreme Court has rendered. You may question the choice. For example, there are many other judgments may have greater impact. such as S.R. Bomai judgment, where routinely the opposition state governments been dismissed by the center at will and fancy, it stopped completely. For example, L. Chandra Kumar judgment, which held that judicial review is a basic feature of the constitution. But I have selected these three judgments for presentation for your thought and mulling over. The reason is that three different judgments from three different fields have a lot of things in common. They change the way that fundamentally we look at the constitution. They have read the judgment beyond the plain words written in it. From these judgments, we learn the concept of constitutional morality. And these three judgments tell us that the constitution framers have left many things deliberately unsaid. And these three judgments therefore give our constitution a needed flexibility. As Justice Srivastava pointed out, Justice S.P. Sinha of Supreme Court has famously said, the Constitution of India is a living organism, an organic body, but the rate of change is glacial. To meet with the passage of time, the changing period from time to time, it can adapt to itself. You may ask me two important questions. Why are these judgments so important, which I have already answered? But second, you may say, why am I telling you all these things? My young friends, I am saying all these things to you because I see hope in you. I see a young, curious and questioning mind. You have the ability to question injustices, inequalities and inequities in the society. The day you start questioning this, consider yourselves brain dead. The Constitution of India in 75 years has been firmly anchored. What better example can be than just see the entire subcontinent? Pakistan, Sri Lanka, Bangladesh, Nepal, Bhutan. India is the only country which has had not a single day of suspension of democracy. This is a true proof of the endurance and durability of the Constitution. But it is not correct to say that everything is fine with the way we are looking at the Constitution. No, much has yet to be done. The dream of the Constitutional framework of true equality, of social re-engineering and restructuring is a work in progress. Look at the number of custodial deaths and fake encounters. Despite judgments after judgments, P.K. Basu and range of judgments, this goes on unabated. There are many things wrong, many things need to be changed, many things need to be improved, many goals to be yet achieved. We have miles to go before we can rest. But what we have done so far is good and it's remarkable. Never forget that. Friends, as first generation women law students entering into this field, you have a greater role and a greater challenge to face. I'll tell you about a woman called Catherine Schweitzer. This name may not probably ring too many bells. Marathon running, as you are aware, is a race of 42 kilometers, the toughest test of human endurance. Boston Marathon is one of the most famous and popular marathons of them all. Till the year 1957, no women were allowed to run in Boston Marathon. Catherine Switzer, 19-year-old student of journalism, decided to change this. She practiced day and night, hired a coach. When she went to run the race, she was jeered, booed, somebody tried to physically throw her out of the race. Enduring all these insults, she carried on. Towards the end of the race comes a hill. Athletes are tired, legs are heavy, and the hill is brutal. It's called Heartbreak Hill. When Catherine reached there, she was exhausted. She wanted to stop. But she told herself that if I stop now, no woman would ever be allowed to run Boston Marathon again. She carried on. 4 hours and 20 minutes after she had started, Catherine Switzer created history by being the first ever woman to complete Boston Marathon. Overnight, she became a cult figure for women's liberation groups to rally around. In 2017, 50 years after her first marathon, Catherine Switzer ran Boston Marathon again. But the difference is, this time around she was not alone. There were 13,000 women running with her. What you do now will make the path for women to follow you easier. Each one of you has a potential to be a real-life Catherine Switzer. Thank you so much.